Case number 116801 in the matter of the care and treatment of Matthew C. Cohn.
Thank you. May it please the court. Sam Ketfield appearing on behalf of the petitioner appellant Matthew Cohn. I would request 3 minutes of rebuttal time.
3 minutes is granted.
Thank you. Procedurally, we're here on a petition for review. Mr. Cohn was the subject of a care and treatment petition filed in 2014 in Clay County District Court. The case proceeded to jury trial in June of 2016. After deliberation, a jury found that Mr. Cohn did indeed fit the definition of a sexually violent predator. The case was appealed to the Court of Appeals with 2 issues. One, that whether or not the actuarial tests, particularly the static 99R and the static 2002R, met the Daubert standard for admissibility, and second of all, whether or not Mr. Cohn himself fit the criteria for pedophilic disorder. The Court of Appeals found that the tests were admissible and that Mr. Cohn did meet the definition. The petition for review was filed, and here we are. The first argument is, of course, goes with the Daubert standard. I think you're probably familiar with that. It derives from Federal Rule 702. Which says that a judge has to be a gatekeeper of scientific evidence. This is an attempt to keep junk science out of the courtroom.
But that's nothing new, Counselor. We had before that we required gatekeeping, except we just used the Frye test.
Yeah,
and we have prior case law that says the static tests meet the Frye test.
That would be the Mallard-Gerard cases out of Clay County. Those were mine too. Yeah.
Okay, so we don't start from ground zero. We start because the factors for Daubert overlap a little bit with Frye, correct?
They overlap some, but not completely. Daubert is a little different though, and I think Kansas is now a Daubert state. I mean, the legislature made amendments to 60, 456, 457, and 458 during the 2014 session that effectively make this a Daubert state.
But we're dealing with the Sexually Violent Predator Act, which has some unique provisions, and we don't have prior case law that says that the Civil Procedure Code provision that makes Daubert the test applies in the Sexually Violent Predator Act. So that's an issue of first impression before us, isn't it?
Well, I would think it probably is, and my response to that would be I think that Daubert has to override what's in it's a civil case. You're dealing with scientific evidence. You can't just carve out an exception in this one area where you don't rigorously test evidence is being used in effect to put a life sentence on an individual. All right. This is that does create a standard of 456, 457, and 458. I think override the Sexual Predator Act. I think that's the larger statute, and I think any Predator Commitment Act has to, if they're going to introduce this evidence, they have to abide by those standards, or else you're just defeating the entire purpose of having rules of evidence.
I'm talking about we're looking at statutory provisions.
Yeah.
And 6456B is where we get the Daubert applicable.
Yeah.
And 5929A06C starts out notwithstanding KSA 6456.
Well, I think that was probably, that provision was probably, I think predates the 2014 amendments.
What would we make of that, if that's right? Wouldn't we be compelled to conclude that when the amendments were passed, the legislature intentionally left alone the exclusion?
No, I think if my position is that if they're going to adopt this test, which I think the Daubert test is pretty much universally recognized. I mean, it's that they're meaning to apply to everything. It applies in medical malpractice cases. It applies in insurance cases. It applies in criminal cases. But for some reason, we don't think that it should apply in predator commitment cases. I mean, this one era, apparently, if you knock Daubert out, you can admit any kind of quackery into evidence. I think the amendments, the 2014 amendments, are meant to override.
Well, I don't think the question is whether there's no gatekeeping. It's
Yeah.
whether we've already determined, already have case law that says Fry applies. And these tests meet the Fry test, and so they get by the gatekeeping. So I'm not asking whether we do away with all, whether that provision meant to do away with all gatekeeping. I'm just saying, did that take the change from Fry to Daubert or Daubert or whatever out of the mix for this particular act?
Fry, if you read the opinion, confined itself to newly invented methods, and that was with regard to the polygraph exam, which at the time was a fairly new invention. But these actuarial tests have been used by the insurance industry for decades. They have been used for sexual predator commitment for at least 20 or 30 years. So I don't think they're a new science. Therefore, by its definition, Fry doesn't apply.
I don't want to take you away from your argument here. That the factors, we have 5 non-exclusive factors for Daubert, and the last one is widespread acceptance. We've already made that determination with the Fry, haven't we?
Yeah.
And so, which of the others, has been tested, subject to peer review, known rate of error, and standards controlling its operation?
Well, you're right. It is generally accepted. I think the static tests are the most widely used, although they're not the only tests that are used in these kinds of cases. Well, is it verifiable and refutable? No. There's a construct validity problem. That's that there's no way, as Dr. Barnett said, to operationalize a percentage risk of offending to determine what the odds are that a specific individual, not just some generic blob of protoplasm, but a specific individual will reoffend and what that number means. They simply don't show their homework. They don't release the data behind the tests, and usually when you're talking about scientific proof and methods, you're required to show your homework. They don't do that. Peer reviewed, yeah.
I'm having trouble with that.
Yeah.
You're saying the data from the original studies or original development wasn't released, so we can't know if it's reliable, but we have testimony here that it's been tested, it's been studied. I think there was one of the doctors said 46 different tests as to whether it's accurate as a predictor of recidivism, and that it's been determined to be scientifically accurate. And so why do we care about the initial development if subsequent experience has answered our question of whether we believe it will be a good test?
You can't test the assumptions upon which it's based. I think that Dr. Barnett said that is essential in deciding. When you say it's verifiable, yeah, these reviews you talked about say, well, it kind of does what it says it does, within a certain margin of error, and that's the other problem I have with it. is that it's peer-reviewed, yes, as to how it functions, but beyond that, no, it's not. But the known error rate, there is no error rate.
On this point, on both the points about the data being released and on the known, the potential error rate, the trial court gave more weight to the state's experts than it did to Dr. Barnett.
Yes.
Which leads me to ask, what do you see our standard of review here is? Can we re-weigh on those 2 points if the trial court made a determination of which was more persuasive?
Well, I'd love you to be able to do that, but I suspect the answer is probably not. I think this is an abuse of discretion standard, so you're not here to reweigh the evidence. But what I'm saying is that as far as the error rate, there isn't an error rate. The closest thing they have is something called the area under the curve, and that's you take two random offenders, one recidivist and one random non-recidivist, and there's about a 70% chance that the random recidivist will have a higher score than the random non-recidivist. So conversely, there's a 30% chance that the non-recidivist will have a higher score than the recidivist. Dr. Crane is placed the area under the curve for the static 99R at 0.678. And for the 2002 R, it was 70. So you got.
How do you get from that 30% to that number?
Excuse me.
How do you get from the 30% wrong to that number? How's that calculated? Is there evidence about that?
Well, it stands to reason that if it's 70% correct, if you're going to have.
So why isn't the error rate 30%?
Well, if you assume that it's not an error rate, okay, let's call it an error rate. They don't call it an error rate.
I understand they don't call it that. Did you ask how they would know when they were wrong? How did you ask them? It's like fingerprints. We always say every fingerprint is unique. Yeah. Don't we? And there's a whole lot of convictions built on fingerprints. How do we know that?
They don't. That's the big problem, is they don't.
Did that question get asked here?
I may have. I'd like to think I did. But that's the problem, is that, you got a 30% error rate. I don't think that's beyond a reasonable doubt. I mean, when you weigh that,
Well, that's what I'm asking.
Short.
How did the experts get from the 30% you just described to the 0.67 or whatever?
I don't know. That's some of that stuff that they haven't released. But, you're exactly right. I mean, it's kind of like that Minority Report where you're trying to stop crime before it happens. Unfortunately, this isn't as sophisticated as that is. It is not... you have a 10 or 12 point checklist here on these tests. And they're very general, and they take. You're not saying, well, Matthew Cohn has let's just say a 30% chance of reoffending. A person with the same score on this test does. Now, that person doesn't have to get the same questions wrong or right. It's just some generic person that scores a 6 on any items in the test. That's the big problem, is it does not particularize any suspicion. And the test itself has problems. There are at least one in the 99R. It asks, well, a history of cohabitation for at least 2 years. If you don't have that, it's 1 point. Well, if you're 18 years old, you're probably not going to have a history of cohabitation with a person. That's one potential bias that leaps right out at me. Another potential bias is that, do you have any male victims? Well, if it's a male victim, you get 1 point. If it's a female victim, you don't. And that's why that data, how they constructed this test is important. I'd like to know why. Go ahead.
If you're going to follow up on that line, go ahead. I was going to introduce him.
I just wanted to ask one question on that male victim reference.
Yeah.
Did they explain why that question's asked?
Nope. I don't recall.
Did you ask them?
I think
male
I
versus
did.
Female made a difference?
I believe I did. They said, well, evidence shows that tends to increase the risk, but again, we don't know because they don't release the developmental data.
Counsel, are we the first court in the country that's been asked to say that static 99 and static 2002 do not meet the Daubert test?
I don't know. I suspect you are not. If there are other cases, I don't know what the arguments were. I don't know what the evidence that is presented was. I'd like to think that my fellow defense bar members have been good enough to raise this question in other courts. But I feel bound to raise these arguments because to me there is something fundamentally wrong with using these tests, which are not designed for this purpose, not initially designed for this purpose, to commit someone to life, effectively life in confinement.
Counsel, sorry.
I was just going to ask, so if I were to ask you what arguments were accepted by those courts and which ones were rejected, you would not be able to tell me?
I can probably supply a 609 letter to you if you wish.
Well, perhaps opposing counsel has some
I would
information
think so,
on
yeah.
that.
But this is the first issue. I will probably save my rebuttal time for the second issue. I'm not abandoning it certainly. But
Justice Stegall had a question. I believe.
Really quickly,
Yeah.
if hypothetically we or I was persuaded by your discomfort with this evidence because of its potential unreliability, but we disagree with you as to whether or not Daubert or i.e. 456B applies, where does that leave us? Is there any route other than through 456B is what I'm asking you.
well, I guess you could, just off the top of my head, I suppose it could be a due process argument that.
Well, you haven't raised constitutional
No, I
claims.
haven't.
I'm saying through the statutes.
Through the statutes.
I mean, you're in tough spot.
Yeah,
right?
I am. I realize that. I always am with these cases. I don't know if there's another route. Are there any other questions?
I see none. Thank you,
All right,
counsel.
thank you.
Good morning, Your Honors. May it please the Court. Assistant Solicitor General Brian Clark on behalf of the State of Kansas. The District Court did not abuse its discretion in admitting the state's experts' testimony, which was based in part on the static actuarial assessments, which are the gold standard in this field. And there was also sufficient evidence for the jury to conclude that Mr. Cohn is a sexually violent predator. I'd like to begin, if I may, with Justice Johnson's question about the applicability and interaction of the statutes between KSA 5929 A06C and KSA 6456B. Beginning in the district court, this case has been litigated by the state saying that whichever test the court wishes to apply, whether it be Frye or whether it be Daubert, the static assessments satisfy those tests. The district court decided to apply Daubert. The state did not cross appeal on that issue, and that is why in both the Court of Appeals and in this court, the case has been litigated on the assumption that Daubert does apply, and leaving potentially for another case to determine whether
But we often say the district court was right for the wrong reason. And if the district court was incorrect in applying Daubert, it would still be correct because we've already determined that Frye applies, right?
that's correct. In the state,
And so even though the state says, yeah, we want you to go ahead and decide this because we didn't cross appeal, doesn't mean we apply the wrong standard, the wrong statutes. I mean, they are what they are.
Sure.
You can't stipulate to a misapplication of the law, can you?
No, Your Honor, and the state would welcome this court affirming on other grounds if it wishes to do so. For example, this court could easily stand on its holding in Girard, saying that the static assessments satisfy the Frye test because they're generally acceptable or accepted in the field. and could affirm on that basis, and the state would be perfectly fine with that. And I think that gets to a second point I'd like to make with respect to the interaction between Frye and Daubert. It's been said in this court's cases that the Frye test, whether a particular scientific method is generally accepted within the field, is just one element or one factor in the Daubert test. But it's worth stepping back and looking at what Daubert was doing. Daubert was not narrowing the field of what experts can rely on, but rather broadening it. And so to the extent for example here, the static tests, they satisfy Frye, and therefore it would be very odd for them not to satisfy the Daubert standard, because it's as I said, it's the gold standard in the field. 95% of...
Where does the gold standard come from?
That's language that was not used in this case that I recall. In this case, all experts, including Dr. Barnett, agreed that roughly 95% of the forensic psychologists doing clinical services reports and forensic evaluations in this context use the static assessments.
So it's popular. It's popular, but it doesn't really speak to its scientific validity at all, does it?
Well, it says that the experts in the field almost universally use it. And if we want to back up and look at some of the other Daubert factors with respect to whether it's testable, that goes to its scientific validity. And with respect, the static assessments are testable. And the way that Daubert is applied, that particular factor is, the question is, okay, what is the scientific hypothesis on which the tests are based, and then can follow-up study be done to determine whether the tests are reliable or not?
That's all based on, that's experiential, that's subsequent experiential information, right?
It's subsequent experiential information, but in this case, the statics, for example, there was a test involving 7,000 sex offenders. Mm-hmm. They were tested on both the Static 99 and the Static 2002R, and then they were followed to determine and looked at how many of them reoffended, how many of them did not, and to determine how accurate the static assessments were.
And the static assessments were administered before they were followed, not after they'd been followed and compared to how they behaved.
That's my understanding, correct.
Okay. That matters, doesn't it?
I think so. And
yeah,
and the way that a lot. I think you're right.
How does Daubert broaden the number of tests that would be considered? Because I think it's universally understood to have made it more difficult to admit this sort of testimony, to increase the number of hurdles it must cross before admission.
So I think Daubert did two things. I think it increased the rigor with which district courts perform their gatekeeping function. Mm-hmm. But if you look at the Daubert case itself, in that case it involved the question of whether Bendectin caused birth defects. At the time, there were studies by a whole bunch of experts saying, no, we've done these studies and Bendectin does not cause birth defects. Well, the plaintiffs wanted to introduce expert testimony by minority experts saying, well, if you look at these other studies that might be in the minority, there's some argument that actually, yes, Bendectin does cause birth defects. And the district court in Daubert said, well, that doesn't matter because all we look at is whether the scientific method is generally accepted. Plaintiffs, your experts, don't rely on tests that are generally accepted and so excluded. The U.S. Supreme Court said, no, that's not the limit of the test. We will allow district courts, the federal rules of evidence allow district courts to look at more than just whether the particular test is generally accepted. You can look at all these other factors, and even if the tests are or the scientific method is in the minority, it may still very well be reliable and relevant and therefore should be admissible and subject to the adversarial testing process. And going back to your question, Justice Lukert, about what the standard of review is, the weighing of the evidence, and here with respect to the application of the Daubert test, the standard of review is abuse of discretion. And so all of this was aired in front of the district court, all of the arguments that you're hearing this morning. The district court heard the evidence, weighed it, and credited the state's experts over the testimony of Dr. Barnett. And on appeal, the appellate courts do not reweigh the evidence. And so we would submit that on the standard of review alone, the state should prevail.
So the fact, since we can't reweigh, the fact that the two test results of the two tests were that Mr. Cohn had between an 18 and a 40% chance of reoffending, that we just have to accept that as reliable.
So I think you accept it as reliable for purposes of allowing the experts to testify at trial, and then
That's
that
kind of counterintuitive to say you could have over two times difference in the probability. I mean, when you deal with probabilities, the difference between 18% and 40% is pretty significant if you're going to place a bet. But we go ahead and accept that for recidivism purposes, that's reliable.
So the range that you're citing is, I think, taking the low end of the static 99R and the top end of the static 2002R.
Exactly.
And those two tests had different ranges that were narrower, that were based on a 95% confidence interval. And then Dr. Grimmel testified that when both of those tests are taken together, their accuracy actually increases rather than decreases. So I take issue a little bit with the premise, to the extent that I don't think that we can take the bottom end of the static 99R and the top end of the static 2002R and call that the range. I think when they're considered together,
Well,
the
what
range
we
would
can do is, but you're putting that in front of a jury, and you're
Right.
putting those percentages, and the witness is saying, those percentages, and when 40% comes out of the expert's mouth, a juror's going to go, oh my gosh, more than almost half of these people are going to reoffend, so we've got to put them away. Whereas the other test has less than a fourth at the top end.
Right, and with respect, both numbers were presented at the trial and presented to the jury. So, and they were subject to cross-examination. And what Daubert says is when a test is relevant and reliable, it should be submitted to the jury and let it be tested by the adversarial process. Our experts were attacked on cross-examination and through Dr. Barnett's testimony. There was competing testimony about the validity of the tests, and what Daubert says is that type of vigorous cross-examination is the cure for the types of concerns that you're suggesting, Justice Johnson. And so with respect, both of our experts said that both the static test, the static 99R and the static 2002R, were almost ethically required by them to use as part of this process.
Why is that?
Because it's standard in the field.
Because it's the gold standard, right?
Correct.
Okay, so that leads to my question. Back to
Yes.
sort of the theoretical underpinnings of Daubert. My understanding, sort of in a plain-spoken way, is that Daubert's the intent there, the theoretical underpinnings, were to suggest we've now realized that popularity and consensus is not a good foundation to build our what is evidentially reliable. And so we're going to shift away from talking about consensus and what the scientific community in the aggregate believes and popularity, because, wow, we have pretty compelling instances when the consensus was wrong. And we're going to shift to talking about actually objectively measurable factors, which, again, aren't perfect, but we think are a better measure of reliability. And reliability is what matters, not popularity, not consensus. So I hear a contradiction inherent in your argument. You want to suggest that these forms can pass the Daubert standard because they're the gold standard. So, but that's really, as I understand it, not what we want to look at, is consensus in the community. So my question specifically, I know that was a long lead-in, is what did the district court rely on specifically? I mean, the court did conduct a Daubert hearing, but what specifically did the court rely on to support its ruling that these reports or these forms were reliable under the Daubert standard? Was it anything other than scientific consensus?
Yes, and if I may, I think the reason why I emphasize scientific consensus is not a way to short circuit the process of putting these tests through the rigors of Daubert, but rather there is scientific consensus because these are good tests that do satisfy each of these Daubert standards.
That's just circular.
So
what specifically?
Right. So let me take you through the three factors that Mr. Cohn challenges here. The first is whether it's testable and refutable. But Dr. Grimmel said yes. The hypothesis is whether a sex offender with a higher static score is more likely to reoffend than a sex offender with a lower static score. That's been followed up. He testified that there were some 42 studies that were done, and this is predating 2007, to determine whether this is true or false. And those studies found that the statics are reliable in determining whether a person is more or less.
Well, whether or not it's reliable is the legal conclusion. Do you agree with your opposing counsel's assertion that those reliability tests reported a 30% error rate?
No.
Help explain that.
So we're talking about two different things, I think. So the testable question is one thing, the error rate is a separate thing, and Dr. Grimmel testified that there are two sources of error in these tests. One is how the tests are conducted. That is reflected in an intra-class coefficient of 0.85 on a scale of 0 to 1, which in the field is considered to be good to excellent, so that's one source of error. The other source of error is the predictive accuracy, and that's tested by the area under the curve. And in this case, Dr. Grimmel testified that it was 0.72 for the static 99R, and I believe Dr. Crane at trial testified that it was 0.68, so there's some discrepancy there.
And am I right? I'm just trying to translate these statistics into my mind.
Right.
Does that mean, when you talk about 0.72, 0.68, does that mean 72% accuracy, which would then, by subtraction, mean 28% error rate versus 68% accuracy, 32% error rate?
Yeah, so the 72...
So we are in the range of 30%, that
So-
they're not right.
So let's start with this. I think it's helpful to start with the 72 and then get to the 30, because the 30 was not...
Let's start with 0.5. Let's start with 0.5.
Okay.
Because my understanding on the area under the curve is if you had 0.5, it was a coin toss.
Correct.
That
was the
half
testimony.
would have been accurate and half would have been inaccurate.
Correct.
And so that's a little different. So you're looking at the range between 0.5 and 1.0, correct?
Correct.
Okay.
Right, and so the 72%, which would be 0.72, what that is saying is that there's a 72% chance that a randomly selected recidivist will have a higher static 99R than the randomly selected non-recidivist.
Which necessarily means that 28% of the time, those studies don't indicate the right person.
Well, so we have to get back to what these studies do. What these studies do, and again, they're just one part of an overall comprehensive evaluation.
That's subject to argument. We're just trying to get to reliability here.
Right. So what the studies do is they say that a person with this static score
72% of the time will reoffend. And that means 28% of the time is not as likely to reoffend.
Well,
I mean, it divides the population. The test divides the population, and there's a correlation for 72%, but not for the other 28%.
right, and then it varies by the score that a person would get, and that gets to the probabilities that Justice Johnson was talking about earlier. And I'd like and just to back up and say, again, all of this was presented to the district court. All of this is subject to abuse of discretion review, and so this court would have to find that no reasonable person could have concluded that these tests were reliable enough for the experts to use and therefore present to the jury. With respect to your question, Mr. Chief Justice, about other courts, I haven't done sort of a scorched earth every district in the country sort of search, but I do know that the Wisconsin Court of Appeals and the Federal District Court of Massachusetts both have held that the static tests satisfy the Daubert standard. And so there is precedent out there for affirming, for reaching the same conclusion that both the district court and the Court of Appeals reached. And with respect to the adversarial nature of the way the evidence was presented, a lot of the arguments that were made, there was no scientific backing behind it. Our experts came in and they said, this is how you test it. This is the intra-class coefficient. This is the area under the curve. This is why they're reliable. And on the other hand, Dr. Burnett simply said, I don't like them, I don't use them. And so I think that's what this court is left with as well. He didn't know what the area under the curve was. He didn't know how to challenge that in a scientific way or give a reason.
But he did know that it's not an individualized assessment. It's if a person answers the questions this way, then all the other people that answered it the same questions the same way get this score. And so this person can have some, well, you've admitted that if he'd had sex offender treatment, and if he'd been cured, if you had somebody came in here and says, hey, he's cured of his problems, that wouldn't change the score for him.
Right, so that I think this is important to keep the tests in context, because that wouldn't change his score, but it could change the expert's conclusions or opinion. And so I think the argument that the statics don't take into account things like sex offender treatment is actually a feature of the static assessments. It's not a bug, it's not a defect. Those other considerations are taken into account in the comprehensive evaluation. So, for example, on the other side, the static assessments don't take into account the fact that our two experts, at least, diagnosed him with pedophilic disorder, which dramatically increases a person's likelihood of reoffending. Those dynamic factors are taken into account in other aspects of the evaluation. As this court has recognized and said in the past that the static assessments are not meant to be a silver bullet. It's not the only thing that these experts are relying on. It's part of the mix, but it's not the totality of it. And with that, I recognize I'm out of time. If there are any questions on the second issue presented, I'd be happy to take those. Otherwise, unless there are any further questions, the state would ask the court to affirm Mr. Cohn's commitment.
Any further questions?
I do. If we disagree as to the substantial competent evidence with respect to the determination of antisocial disorder, would pedophilia be sufficient?
Yes, Your Honor, it would.
Okay.
Any more questions? Thank you, counsel.
Thank you.
it's important to remember that these are static tests. They measure factors which do not change. The state has now recently begun using other tests such as the Stable and Acute 2007, which do measure dynamic factors, things that can change. As Justice Johnson said, Mr. Cohn did have sex offender treatment. He might have been cured or significantly the risks significantly reduced, and those tests attempt to do that. As far as him saying, well, this is only one part of it, well, the state puts out these tests, cloaks them in this very imposing mantle of scientific validity, and then says, well, but other things count. A jury hearing these tests, this scientific evidence, is going to be inclined to believe that over mere clinical judgment. And in fact, it didn't really matter in this case because Dr. Crane and Dr. Jimenez-Johnson in particular completely disregarded anything Mr. Cohn said. I mean, I think that was partly class-based because Mr. Cohn is not a very high-functioning individual, has had a chaotic background, and he simply doesn't process information or express thoughts in the way that they do. So they tended to really disregard anything he said about taking steps to prevent his reoffending. As far as the accuracy, also note that the state always throws in, well, these tests underreport because there are plenty of offenders that get out and commit new offenses, but they aren't caught. So that in itself, I think, causes some concern about accuracy. And I think you would also admit that there are folks who are convicted who are wrongfully convicted. So those two factors, I think, have to be taken into account. And as far as the reliability, I think if you go through the record, you will see that Mr. Cohn in October of 2014 was rated a 6 on the static 99R, and 8 on the 2002R. In April of 2015, he was rated a 5 on the 99R and an 8 on the 2002R. And in June of 2016, he was rated as a 6 on the 99R and a 9 on the 02R. So they can't even get the same result with the same person. As far as the second point, the diagnosis, I'm going to say this, that the part in my brief that I outlined that for pedophilia to be diagnosed, you have to have these persistent, intense fantasies involving children for a period of 6 months. That's where the state's case falls flat, because Dr. Crane simply inferred that from her review of the evidence. And Dr. Johnson said...
that can only happen, that diagnosis can only happen if we have an admission to that fact?
I mean, admission certainly helps, but without that, I think you have to really start getting creative and start inferring things. And I think at this point, you're inferring far too much. She used a 2012 police report, but that was hearsay. She hadn't looked at the report or viewed any of the videos, and I'm sure you'll recognize it. Police interrogations can be quite deceptive sometimes, and they're designed essentially to get people to convict themselves. But there was, this amounts almost to negligence. I mean, just inferring this from these vague statements that Mr. Cohn made. So without a pedophilia diagnosis, again, the state's case falls apart. Now, whether they could use antisocial personality, you could, as the Court of Appeals asked me, well, gee, couldn't we use antisocial personality to support it? Let's get real. He's not there because he's got an antisocial personality diagnosis. He's there because he had a pedophilia diagnosis.
But how do we get there? How do we get there? We have an expert that's qualified as an expert, makes a diagnosis. We have a district court that says, I find that expert credible. And you're up here arguing the bases under which the diagnosis was made, and we don't serve that function. We don't determine that the doctor was incredible when I think he and she testified that diagnosed your client with pedophilia.
I'm simply saying the evidence doesn't support that finding of the diagnosis of pedophilia.
You're saying that a qualified expert in the field that makes opinion is not substantial competent evidence of that diagnosis?
Experts can make mistakes. I don't think that
Let me, I see you're out of time. Let me ask you quickly. Is there any distinction between the generic description of risk, as in high, moderate, or low, versus the percentage numbers? You understand what I'm saying? Would these static tests
Yeah.
meet Daubert if they were in the wide category that this indicates that there's a moderate, this person has a moderate, versus putting a number on it?
Well, I don't think so, because moderate risk, again, is kind of, a fuzzy concept. I mean, what I would consider a moderate risk might not be what you would consider a moderate risk. I mean, I think really these tests are shot through with problems. I mean, if you put a number on it, you get this wide spread, as you pointed, anywhere from 18 on one, a low of 18 on one test to a high of 40 on another test. That I think is just a little too broad. And then if you try to say, well, he has a low risk, that's subject to even more interpretation. Did that kind of answer your question? Yeah. Okay, thank you.
Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.